This hearing is in the matter of cases CFI 033-2022 and CFI 060-2022 before His Excellency Justice Shamlan Sawalehi. The claimants are represented by HFW Middle East LLP. Lead counsel is Ms. Zoe O'Sullivan, KC. The defendants are represented by Gliding Poe. Lead counsel is Mr. Richard Little, KC. The sitting of the DIFC court is taking place in Dubai, although His Excellency Justice Shamlan Sawalehi, as the judge hearing the applications, is appearing in Dubai remotely by means of Microsoft Teams. Any orders made in the course or at the conclusion of the hearing will be made on judge's instructions by the registry in Dubai. Will both the judge and counsel please confirm that they are fully aware that the procedure is as I have stated?
Yes.
Is it both counsel appear from Dubai, or I believe one of them from London?
My lord is Mr. Liddell on behalf of the defendant. I'm in London today.
Yeah, I can see a background.
I'm in Dubai.
Yeah. I can see Mr. Richard background. Doesn't seem Dubai at all. All right, I think you have agreed timetable, so let's start with what you have agreed already.
Yes, I'm Mr. Liddell for the defendant, Dubai Insurance Company, PSC. The defendant in claims, my lord, that are brought by Westford Trade Services, DMCC, and by Westford UK Limited. Ms. O'Sullivan, King's Counsel, acts for both claimants, DMCC and UK. There are two applications listed before you today. The defendant's application to consolidate the two claims, essentially to have the two claims heard and determined together. And then the claimant's application, UK's application, I should say, to stay the UK proceedings. My lord, the consolidation application predates the stay application, and hence it's been agreed that I will make submissions first, followed by my learned friend, with both of us then making some short responsive submissions. And as you say, there has been an agreed timetable, essentially a chess clock, which we will endeavour to stick to. Very recently, my client issued what's been called in the skeletons as the timetable application. And that was an application seeking to postpone various procedural steps in the existing DMCC proceedings and to vacate the trial date of the 3rd of July. I'm told by my learned friend that this application, which was dealt with by consent, has now been issued and approved by the court. I don't know whether your lordship is aware of that. I don't have any sealed order, but I can take you to the draft consent order and show you that.
Yeah, please take me to this one as well. Yeah.
The draft consent order you will find, there is the hearing bundle you have electronically. I've also been working from a PDF of that, and you'll find it at section B6.
1 second.
It's page 150 if anyone's working from the paginated version.
All right.
So, my lord, you'll see this is a draft consent order in the DMCC proceedings, referring to the proceedings and the various applications, and referring in the preamble at the end to an amended defence that the defendant has recently served. And as to the draft order itself, paragraph 1, that there be permission to file an amended reply to that amended defence, and that will be due on or by the 8th of May 23. The timetable application is withdrawn. And then at paragraph 3, the pre-trial review that was listed on the 30th of May and the trial of the claim listed for the 3rd to the 7th of July are vacated and are to be fixed. And then various provisions of the existing case management order to be set aside. Essentially, that includes, my lord, witness statements, expert reports, other directions leading up to trial, and are to be substituted with a case management order to be determined by this court following the determination of the applications that you're hearing today. That's the consolidation and the stay applications, and also the other pending application, which is a non-party disclosure application made by my client against the liquidator of Phoenix DMCC, and that there be no audience to costs. So, my lord, I'm told, as I've said, that consent order has now been approved by the court. And I'd ask you to bear that in mind when considering some of the assertions made or have been made by the claimant in relation to the prejudice they would suffer if there were to be consolidation and the trial of the 3rd of July were to come out of the list. Of course, that now has been superseded to some extent by this order. My lord, can I then just finally, by way of housekeeping, just confirm that you have had an opportunity to read the skeletons of myself and also my learned friend?
Yes, I did.
I'm grateful. If I may then move briefly to the backdrop to these applications, which you will be familiar with to some extent, having read those skeleton arguments. DMCC and UK, as I'll call them just for convenience, are related companies. They have the same CEO, Ms. Hande Elmina, and Ms. Elmina has signed statements of truth in each set of proceedings. The claimants describe themselves in the particulars of claim as commodity traders who specialise in supply chain management. And it's understood by the defendant neither of the companies, and certainly not UK, are currently trading. Now, DMCC and UK were joint insureds under a single buyer credit insurance policy. And that was underwritten by the defendant with Phoenix DMCC as the single buyer. And my lord, Phoenix is in liquidation, and Mr. Paul Leggett is now the liquidator. And if I could just ask you briefly to turn to the policy, and the policy is at page 188 of my paginated bundle, and I'm just finding the reference for you. It's at D1.
Yeah. I'm working from my PDF, not from the system, so no worries about reference.
My lord, can I just check then? Do you have a paginated version?
I have, yeah.
That's helpful. So it's could I ask you to turn to page 188, and you should have there the policy schedule.
Yes, I do have.
Yes, and you'll see on page 188 the two claimants, DMCC and UK.
Yes.
You'll see at number 6, the name of the buyer is Phoenix. The policy type at number 9 is a single buyer credit insurance. The policy period over on the next page at 189 from September 19 to August 20. And then if I could ask you to move to page 192, and you'll see at clause A1, the insuring agreement. So in consideration of the payment of the premium, subject to and in reliance upon statements made to the insurers by the insured, and in strict accordance with the policy schedule and endorsements made as part of the policy and its terms and conditions, the insurer, so that's the defendant, agrees to indemnify the insured for the insured percentage of loss, and just pausing there, that's 90%, in excess of the deductible incurred in connection with eligible shipments and caused directly by insolvency, default, and so on. Now, the definitions, my lord, are at page 205.
205, yeah.
And at number 16, you'll see that eligible shipments are defined as meaning any and all shipments and or services of goods made to the buyer, that's Phoenix, during the policy period pursuant to a contract of sale, delivered as required under the contract and sold for contract currency. And then you'll see the definition of shipment is at number 35 on page 207. And shipment means the delivery of goods and or services to the buyer, which shall be deemed to take place when the goods have left the control of the insured for the purpose of delivery to the buyer and or when services have been performed and invoiced. So those are the key definitions relating to the insuring clause. If I could just ask you to go back, if you may, to Will, to page 192. And this is back to clause A. And you'll see underneath the insuring agreement clause we've just looked at, clause A2 deals with joint policy and states that the obligations of the joint insureds, and that's DMCC and UK, so the two claimants in the two proceedings, shall be joint and several, save where this policy states that one insured party shall have the obligation. However, even when one insured party has the obligation under the policy, if that party breaches the obligation under the policy, the insurer will have the same rights and remedies against the joint insureds. And as we'll see in a moment, that clause is relied upon by the defendant in each of the two sets of proceedings and features heavily in relation to the consolidation application and my client's opposition to the stay application. Various breaches of the policy are alleged and relied upon by the defendant, including a breach of clause C1. And if I just take you to that, for example, at page 194, you'll see that it's a condition precedent to the contract at C1 and no material change to the credit management procedures, that the insured will not vary or change its credit management procedures in any material way without obtaining the insurer's written approval. And any joint insured, and just pausing there, the UK was added as a joint insured, is subject to the same credit management procedures. And that's one issue that features, my lord, in both defences, that on the defendant's case, there was a breach by DMCC and UK of clause C.1. And then just finally, in relation to the governing law and jurisdiction, that is provided for at page 200 at clause 13, where the policy is stated to be construed under and governed by the law of England, and the DIFC courts shall have exclusive jurisdiction of any dispute hereunder. My lord, what followed is that in May 2020, the claimants jointly claimed under the policy. And you'll see that at page 210. You should find a document there headed claim form. Yes. And you'll see there under the heading policy, the reference to the insureds named as appearing, which are DMCC in the UK. And the claim relates to 3 orders. And you'll see that under the heading on that page, circumstances of the loss, you'll see the question was, what was the date of the loss? And then you'll see that the answer is March 2020 for order 11893 and 11894. And then 16th of April 20 for order 11927. And my lord, the first 2 orders, that's 11893 and 11894, those are the 2 transactions that are subject of the UK proceedings. The other, which is the 11927 order, is the transaction that is the subject of the DMCC proceedings. The defendant declined cover in relation to those claims on various grounds and has avoided the policy. And my lord, it's evident from the claim form and particulars of claim in each case that the nature of the claims is essentially identical. And that is that the claimant claims to have purchased goods from a supplier, those goods being rice, and then entered into a back-to-back sale of the goods to Phoenix. And each claimant claims to have been provided with the original bills of lading, which it contends were provided to Phoenix. And the claimants say that as they haven't been paid for the goods by Phoenix, and that Phoenix are in liquidation, they are entitled to recover 90% of the sums from the defendant under the policy. And more recently, UK has amended their claim, and I'll come back to that in a moment, to seek declaratory relief in respect to the indemnity that they say they're entitled to, as opposed to an order that the defendant pays monies. And that is essentially a safety net for UK in relation to the fact that the loss payee under the policy is a sanctioned entity. My lord, it's also evident from the defences to each of the claims that the central planks of the defence are identical. For example, the defendant contends that there were no eligible shipments and that the transactions were paper transactions with no movement of stock or transfer of title, and that Phoenix had already purchased the goods in each case prior to the claimant's purported purchase from the buyer, that the claimant breached the policy in various respects, including, as I've already said, their credit management procedures. And in each claim, my lord, the defendant relies upon the other claimants, so the non-claimants' breaches of the policy. And if I could just ask you to turn to page 38, you should find there paragraph 48 and 48A of the defence in the DMCC proceedings. Yes. And you'll see that paragraph 48 refers to the claim that has been brought by UK. So that's the other set of proceedings, the UK proceedings being substantively similar, that the defendant applied to the court for an order consolidating the proceedings. And then, excuse me, at 48A, it's a verb that, as is evident from the defendant's defence in the UK proceedings, the defendant contends that UK Limited has breached its obligations under the policy in various respects and that the policy is void. And without prejudice to the contents of this amended defence, pursuant to clause A.2 of the policy, that's the joint insureds provision we looked at already, the defendant is entitled to rely upon and does rely upon the various breaches of UK in support of its case that the claimant is not entitled to payment under the policy. And then a similar provision mirroring that, for your reference, my lord, is at paragraph 81 of the UK defence, and that's at page 117. And whilst the claimant, in the context of these applications, says that the defendant has not spelled out or particularised in this pleading the breaches of UK, you'll see there that reference is essentially made shorthand to the pleading in the other set of proceedings, which does set out various breaches that the defendant alleges against the claimant. And then to kind of finish the backdrop to these applications, and as you'll be aware from these applications, in each case, if the claimant were to establish entitlement to cover an indemnity under the policy or a declaration, then the defendant would be obliged to make any subsequent payment to the respective loss payees of DMCC and UK. Now, DMCC's loss payee is a company called White Oak, and UK's loss payee is a subsidiary of a Russian bank, Gazprom, and it's been, the shorthand is BGIS, and BGIS is currently sanctioned following the war, as a result of the war in Ukraine. Could I take you, my lord, to page 790 of the bundle, so you can see
So give you the reference again.
I'm sorry, it's page 790.
Yeah, 79. All right.
I think I hate to interrupt. I'm sorry, but I don't have a paginated bundle, so I mean, following as best I can. It would be incredibly helpful if you could give me references to the electronic bundle.
Yeah,
Thank you.
Yeah.
Can you find the lost payee endorsement? I'm just asking my junior to find the relevant part. It's right towards the end of the court bundle, Mr. Sullivan. It's D4. D4.
Thank you.
D4, yeah.
D4.
That's the Gazprom one. D4.
D4. So it's page 790, my lord. It's the lost payee endorsement in relation to the BGIS. And if I could just ask you to turn on the next page at 791 to the lost payee endorsement terms and conditions. You'll see at section 1 that it states that this endorsement is not an assignment of any rights, obligations or benefits of the policy to the lost payee. B, it does not entitle the lost payee to notify, lodge or pursue a claim under the policy, and gives it no rights whatsoever other than to receive a claim payment as provided for under this endorsement. And I emphasize those words, my lord, no rights whatsoever. And then at 2, payment of any loss is subject to the terms and conditions of the policy. And at 3, once this endorsement has been issued, the defendant is, that's Dubai Insurance, is obliged to make payment of any amounts due and claimed by the insured under this policy to the lost payee, if and only if any claim is payable to the insured under the terms and conditions of the policy. Now, against that backdrop, my lord, can I turn then to address you briefly on the consolidation application? That's the defendant's application, which you will find the notice at page 170. Mr. Sullivan, I assume you've got that and know where that is in the bundle. My lord, the DMCC proceedings were commenced on the 9th of May 22. The UK proceedings were commenced on the 31st of August 22, although my client didn't learn of this until it was served with the proceedings on the 20th of December 22. So both sets of proceedings were commenced after the war in Ukraine and after BGIS was sanctioned. And the defendant's position has consistently been, both prior to and after UK's commencement of proceedings, that the claims should be managed and tried together. And that, of course, remains the position. And the claimant's position has also consistently been that the claims should not be heard together. Although it is not until the stay application was issued on the 27th of February 23 that any reliance was placed on the fact that BGIS was a sanctioned entity, and more recently that White Oak, so that's DMCC's lost payee, didn't wish to be associated with or be perceived as associating with BGIS. And up until that application from the claimants to stay the UK proceedings, reliance had been placed by them upon what they described as notable differences between the claims. Not least, they say, in the name of the contractual party and also the lost payee. Although there were no adequate details provided, my lord, regarding what those notable differences were, other than, as I say, the name of the claimant and identity of the lost payee. My lord, the court will be more than familiar with Rule 4.2 of the RDC, which you'll find at page 882. And Mr. Sullivan, we're just trying to find that
It'll be in the
for you
authority
now.
section, I assume. Yes, thank you.
Yes. It's at F1.
Thank you.
And 4.27 empowers the court to consolidate, and 4.28 empowers the court to try 2 or more claims on the same occasion. I'm sorry, I think we've given you the wrong reference, Mr. Sullivan. It's F5. And then reference is also made by the parties to the Registrar's Direction number 2 of 2014, which is at page 878, just a few pages before the RDC section, and that's at F3. And both parties, my lord, refer to this because whilst at the outset at page 878, there's reference made to the court's power to consolidate where it considers appropriate, you'll see at little 1, where 2 or more cases are pending before the court, if it appears to the court that some questions of law or fact arise, some common questions of law or fact arise in both or all of them, or that the rights to relief claimed are in respect of, or arise out of the same transaction or series of transactions, or that for some reason it's desirable to make such an order, the court may order that those applications or cases be consolidated or joined on such terms as it thinks just, or may order them to be tried at the same time, or one immediately after the other, or may order any of them to be stayed until after the determination of any other of them. So you'll see there that refers to both consolidation and stay, and essentially the discretion of the court to deal with matters as it considers appropriate. And the defendant, my lord, is not proposing that the claim be consolidated in the classic sense of the word, where you have one composite set of pleadings or statements of case. And that's, of course, because as things are happened, there are 2 sets of proceedings where pleadings are already afoot. In the DMCC claim, they are almost closed. There's a reply to come or amended reply to come. In the UK proceedings, there has been a reply already to the defence. There may have to be amendments to the defence once disclosure has been given. What the defendant is proposing is that the claims be managed together and tried together. And in so far as management of the claims are concerned, my lord, there has been no disclosure yet in the UK proceedings, albeit, as Mr. Barlow on behalf of the claimant notes in one of his witness statements, the defendant in the DMCC proceedings has already disclosed documents relating to UK, but there's been no disclosure by UK in the UK proceedings. As for witness statements, witness statement phase hasn't been completed in the DMCC proceedings, nor in the UK. Expert reports haven't been served in either of the proceedings. So whilst the UK claim needs to catch up to some extent, it is not such that the procedural steps are so far apart that these matters can't be tried together in a reasonable period of time once a further case management order has been provided. And my lord, I've got 10 minutes left of my submissions. I don't have the time to rehearse everything in my skeleton, but what I will do is just like to identify what we say are a whole host of factors that militate in favour of consolidating these proceedings. In other words, having these proceedings managed and tried together. The first, of course, the obvious point is it's the same insurance policy. The second is that we have the same buyer, in other words, Phoenix. The third is that the claims involve the Westford entity buying rice from a supplier. In the DMCC case, the supplier was Uno. In the UK case, the supplier was a company called Genuine. And then we have the alleged onward sale to Phoenix, despite in each case, so the defendant avers, Phoenix seemingly having already purchased those goods. And then we have the same core issues, including legal arguments under the policy relating to whether the transaction are eligible shipments, whether the Westford entity was in breach of clause C.1. And indeed, my lord, you'll see that the replies to the defences are very similar. And if I could just ask you to turn to the reply in the UK proceedings at page 119. And it's paragraph 3. I'm just getting the reference to Miss O'Sullivan. It's A11. You'll see, my lord, that the UK states in that reply that its reply advance is intended to rely upon materially the same matters as those relied upon by DMCC in its reply in the other case, that's the DMCC proceedings, and that any differences are matters of drafting only and not intended to indicate the claimant is advancing differing arguments from DMCC. We also have got the same legal representation, certainly with solicitors, HFW for the claimants in each of the proceedings, Clyde & Co for the defendant, same counsel at least for the defendant, and for today's purposes, Miss O'Sullivan, I don't know whether it's going to be the same counsel for trial. We've also got the same factual witnesses. We've got Handy Elminer for the claimant, almost certainly she'll be giving evidence, and the same underwriting witnesses for the defendant. The claimants accept that there's a very significant degree of overlap between the two claims, but in the context of the stay application, as we will see in a moment, they also accept that in normal circumstances, the claims would have been brought in a single action. But they say that global political developments mean these are not normal circumstances. And my lord, I suggest that's an important factor to take into account. That on the claimant's own case, they say, well, these would have been brought together if it wasn't for the fact that BGIS is a sanctioned entity. And as we'll see in a moment, and in opposition to the stay application, we say these are normal circumstances in that the fact that BGIS, who's the lost payee, is a sanctioned entity, does not mean that these cases shouldn't be joined or heard together, and does not mean that the UK claim should be stayed. And one of the limbs to the claimant's opposition to the consolidation application is that DMCC would be prejudiced if the trial had to be vacated, essentially in order to accommodate the UK claim catching up and joining. But my lord, you'll have seen from the consent order that this essentially has fallen away as the trial has been vacated. One of the other limbs to the claimant's opposition to the consolidation application and relied upon by the claimants in the context of their stay application is that my client will suffer no prejudice by the UK claim being stayed, as UK has said they are willing to undertake to be bound by findings made in the DMCC proceedings. And what we say, my lord, in response to that, as you'll see from the skeleton, is that this doesn't cure or resolve the prejudice that is likely to be suffered by the defendant if the proceedings are not joined and if the UK claim is stayed. And that is primarily because of the joint insured issue. And one asks rhetorically, what would happen if the UK claim was stayed? There's been no disclosure yet by UK in the UK proceedings. The defendant seeks to rely upon breaches of UK in the DMCC proceedings, but what is the judge going to do in respect to that? Is he going to try and determine those actions in the absence of that disclosure in the UK proceedings, or the absence of evidence from Ms. Hande Elmaner in those UK proceedings? And my client is not prepared or in a position to give a reciprocal undertaking, not least because it's not in a position to deal with all of UK's breaches at this stage without disclosure, without the opportunity to make amendments to its defence as a result. And as you'll see from our skeleton, there are also real risks of inconsistent judgments if these two proceedings are not tried together. And whilst I have an opportunity to respond shortly to my learned friend's submissions in support of the stay application, of course, those two applications, as I've said, are inextricably linked, because if the court were to find there shouldn't be a stay of the UK proceedings, then the claimants accept that in the normal course, these cases would have been brought together. And when one looks at the claimant's grounds for dismissing the consolidation application and granting the stay application, the principal reason that is put forward, at least in the third witness statement to Mr. Barlow of HFW, is that the Westford UK claim engages concerns about potential breaches of the UK sanctions regime. But this is a case where the proceedings were started after the beginning of the war in Ukraine. And this is a case where it's accepted on behalf of the claimants, on the behalf of UK, that recent authority for the English Commercial Court, that English lawyers are able to act up to the entry of judgment, because that wouldn't constitute dealing with economic resources or funds. And that's at paragraph 22 of Mr. Barlow's third witness statement. And indeed, UK have amended their claims to seek declaratory relief. And at page 342, if you could just turn to that, my lord, you'll see an email, and I'm sorry, Mr. Sumner, I don't immediately have to hand the reference. It's an email of the 27th of February 23 from HFW to Clyde & Co, which deals with the proposed amendments to their claim. And you'll see in the third paragraph that it's stated by Mr. Garrett that the purpose of the proposed amendments is to make it clear beyond doubt that by seeking judgment on the claim in circumstances where the lost payee is a designated person, our client is not seeking to make available a fund. And then it says, in the light of the recent English Commercial Court decision, holding it's not unlawful for the English court to enter judgment, we do not think any argument to that effect would be a good one. Nonetheless, for the avoidance of doubt, our client wishes to make clear it's seeking only declaratory relief. So there are no concerns in relation to the fact that the UK it has a lost payee, which is a sanctioned entity. And we say the position is straightforward. The undertaking doesn't do the trick. There's emphasis now placed by UK on it deriving no financial benefit from the UK claim, because as a borrower, it's obliged to pursue the proceedings. We haven't had disclosure, I don't think, of the facility agreement, but in any event, that's not a relevant factor. They say it's disproportionate to require UK to incur costs of pursuing the claim. But this is the claim, my lord, that they have pursued, and the defendant is entitled to defend. The claims cry out in my submission to be managed together and heard together. There's no justification for a stay of the proceedings. And any stay in any event should only be granted in exceptional circumstances for compelling reasons. And there aren't any in this case. So, my lord, that's my 40 minutes up. And I'll now pass to Ms. O'Sullivan, unless I can be of any further assistance at this stage.
Thank you very much. So let's turn to the claimant counsel. Yeah.
My lord, the stay application is very much the mirror image of the consolidation application. It was issued in opposition to the consolidation application, and so I will address both points together. My lord, the fundamental point is this: why should Westford UK be forced to incur the expense and effort of pursuing a claim which it does not wish to pursue, from which it will obtain no benefit, in circumstances where we have made a pragmatic and reasonable proposal, which has inexplicably not been accepted by the defendant? That we say the undertaking we have offered, to be bound by the findings of the court in the DMCC proceedings, addresses all their concerns, and their objections are not well founded. So that's the fundamental point. My lord, I just want to say something about the test, because my learned friend has now submitted orally and in writing that the court can only grant a stay in rare and compelling circumstances. My lord, that is not the test. The test is whether it is in the interest of justice for the court to grant a stay in the particular circumstances of the case. I'd like to show you the Athena Capital case. You'll find that in the legal authorities section at number 9. I'm afraid I don't have a paginated bundle, so I can't help you with the numbers. But the legal authority.
I've seen it, so no worries.
So it's F9. And within that, I'd ask you to go to page 17 of 23.
Yes.
Sorry, I'm afraid my system is a little slow to load. Bear with me, my lord. I'm afraid it still hasn't loaded. Oh. Here we go. Oh, here we are, at last. Okay, so within, if you go within that to page 17. And paragraph 58. And what the court is observing there is say, well, it's interesting to see how an observation by Lord Bingham that because in fact it would only be in rare cases where there was a compelling reason that a stay of English proceedings would be granted. He says that's been elevated almost into a legal test, that rare and compelling circumstances must exist before the apparently unfettered jurisdiction to grant a stay can be exercised. And he goes on to say, there's no reason to doubt that it is only in rare and compelling cases that it will be in the interest of justice to grant a stay. But he goes on to say, in my judgment, all of the guidance in the cases which I've cited is valuable and instructive, but the single test, the legal test, remains whether, in the particular circumstances, it is in the interest of justice for a case management stay to be granted. My lord, in any event, we submit that the circumstances of this case are rare and compelling. These claims started life together as a single claim under a single insurance policy, and absent world of events, no doubt would have proceeded to a single claim. But they've been split apart by the occurrence of world events which the parties did not foresee and outside their control, namely the invasion of Ukraine by Russia and the resulting imposition of sanctions, including sanctions on PGIS, which had become the lost payee before the outbreak of war. If Westford UK is forced to continue this claim to trial, it will inevitably incur expense. For example, we've been told by the defendant it intends to make an application for security for costs against Westford UK. And that must be made on the basis that the defendant expects to incur significant costs, which are specific to Westford UK's claim. If security is granted, Westford will have the burden of putting up a substantial sum to enable it to pursue proceedings from which it has nothing to gain.
Yeah.
The objections made by my learned friend are really that, firstly, the defendant doesn't want to be forced to try the same facts twice, and it wants to be able to rely upon breaches of contract proven against Westford UK in defence to DMCC's claim. We understand those concerns, and that's why we've offered the undertaking to be banned as if Westford UK were a party to the DMCC proceedings. Now, my learned friend in his skeleton seems to cast some doubt as to whether an undertaking of this sort is valid and enforceable. Of course it's valid and enforceable. The undertaking would be given to this court. It would have the same force as court order. If Westford UK were to try and have the issues redetermined in the future proceedings in breach of the undertaking, the defendant's remedy would be to strike out the relevant parts of the pleading as an abuse of the process. The defendant says it is not prepared to give a reciprocal undertaking to be bound by findings against it. Westford UK is prepared to take that risk. If Westford DMCC wins its claim, and the defendant insists on relitigating all the issues again, the defendant will be running a very serious risk in costs. We submit that it's vanishingly unlikely that the defendant would seek a second trial if it loses the first one. The main point relied upon by the defendant is its wish to rely upon breaches by Westford UK in support of its defence against DMCC, because they're joint insured. Nothing is stopping them from pleading and proving such breaches. My learned friend has already taken you to its pleading, where breaches by Westford UK are relied upon, although they're not actually identified. My learned friend suggests that the trial judge might be reluctant to make findings against a non-party. That's very odd in my submission, my lord. Judges frequently make findings against non-parties. A party might not be joined to an action because, for example, it's become insolvent. It's not worth powder and shot. But that doesn't stop the court from making findings of breach of contract against it if such findings are a necessary part of another party's cause of action. The non-party, of course, wouldn't be bound by the judgment, but that is precisely why we are offering to be bound by the judgment as if Westford UK were a party. My learned friend says disclosure has not been given by Westford UK. But in fact, as we know, Westford DMCC has already given documents which relate to the UK. The defendant is making a third-party application against the liquidator of Phoenix. That application relates to documents covering both companies. My learned friend has made no attempt to identify any documents that Westford UK might have which are unique to it and will not be obtained by the normal process of disclosure by either DMCC or from the liquidator if my learned friend's application succeeds. But most importantly, my learned friend has not identified any breaches of contract which are unique to Westford UK. And he's emphasised the fact that the claims against both the defence are in effect identical. The breaches relied upon as against Westford UK are the same breaches as are relied upon as against Westford DMCC. They are indistinguishable. I would like to show you how the Westford defence to the Westford UK claim has been pleaded. If one looks at section A, number 10, And I just want to scroll through some of this to show you that essentially the same allegations made against both parties.
Yes.
So, for example,
A10.
yes, I'm afraid mine is a little slow to load. Yes, so this is the defence. Yeah, if you scroll down, for example, to paragraph 5.
Yeah, page 96.
Yes, it said there the claim is substantively similar to a claim brought against the defendant by the claimant's sister company, DMCC. If you go down to paragraph 8.4. You'll see that a core pillar of the defence relates to a term sheet provided by DMCC to the defendant as part of the proposal. And it said, in effect, that this term sheet forms part of the credit management policies of both claimants, and that they made changes to their credit management policies without the consent of the insurer, thereby entitling the insurer to decline cover and avoid the policy. So again, that central defence is identical in relation to both claims. So to the extent that there is a breach is alleged against Westford DMCC, exactly the same breach is alleged against Westford UK. And similarly, if we go down quite a lot further, if you can scroll down now to paragraph 71. Again, so there's a heading there, conditions precedent the contract. And there, as I've said, there is the allegation that the claimant varied and changed its credit management procedures in a material way without obtaining the defendant's written approval. The identical allegation is made against Westford DMCC. The same documents, the same facts. And this is my last point on the pleading. Similarly, if you go down to paragraph 74, it said there, as an alternative ground of defence, that the clause required the claimant at all times to act prudently and as though uninsured, use due diligence and do and concur in doing things all reasonably practicable to avoid and diminish any loss. And again, that breach is exactly the same breach which is alleged against Westford DMCC. In other words, although Westford UK claims arise out of different contracts with Phoenix, the allegations of breach are the same across all three contracts. And the defendant itself has made a point in its evidence of emphasising that the factual differences between the two claims are so small that they're immaterial. So we say there is obviously no real risk of any injustice to the defendant if the Westford UK proceedings are stayed. The arguments put forward by my learned friend are purely speculative and theoretical. In addition, they are, we say, the legitimate concerns of the lost payee of DMCC, White Oak, about being associated with a claim apparently brought for the benefit of a sanctioned entity. Now, the legal position in relation to sanctions has become a little clearer since January, with the handing down of the commercial court claim. But that doesn't mean that the reputational risk has gone away. And that is a circumstance which I invite this court to take into account. I mean, what you're being asked to do is to take into account the relevant circumstances, balance up potential injustice to one party if the order is made, potential injustice to the other if it's not made, and choose the course which will cause occasion least injustice. We submit that the injustice to Westford UK, if forced to continue with its claim, is very real and substantial. I mean, Westford UK, as it's made plain in the evidence, only ever issued this claim because it was at risk of becoming time-barred. And it was impossible. It turned out not to be possible to agree a standstill agreement, which would be in the obvious course. So it has no benefit. It gains nothing under the policy, and yet it cannot simply walk away and abandon the claim because it has a duty to the lost payee to pursue the claim. So it's really caught in a cleft stick. It's done the bare minimum to advance its claim in these proceedings. And it is clear that there will be a substantial additional effort and expense if it is forced to continue with this claim. On the other hand, we say that there is no risk of any injustice to the defendant because of the very pragmatic undertaking we have offered. We simply cannot understand the objections made. It said there's a risk of inconsistent judgments. Well, no, because we are saying we will abide by the findings made in the DMC proceedings. So there will not be relitigation of the same issues. There will not be inconsistency between different judgments. And it's an offer which should have been accepted, my lord. And it's something that you should take into account in exercising your discretion to order a stay and dismiss the application for consolidation. Those are my submissions, my lord, unless you have anything you would like to raise with me.
No, nothing at all. So shall we give the defendant counsel opportunity to reply or to make any comments? Get back to you. Yeah. Please, Mr. Richard.
Yes, my lord, we were certainly ahead of the schedule, and it was agreed I would make some responsive submissions, and then my learned friend also has the opportunity to do likewise. My lord, as I stated in my opening submissions, one has to remember that the starting point is, on the claimant's own case, that but for these what is described as essentially abnormal circumstances by the claimant, these two matters would have proceeded together. And so therefore, when one looks and considers my learned friend's submissions as to, well, we provided an undertaking, this is all pragmatic and so on, if the claimants can't persuade your lordship that these are abnormal circumstances and that there are circumstances that justify these proceedings not being heard together or that the UK should be stayed, then these matters should all be heard at the same time. And so I'd ask you to bear that in account when you consider and review my learned friend's submissions. And on a number of occasions, both in writing and orally, UK submits that they have nothing to gain. I think that's the exact words that were used this morning. Well, they are obliged to pursue this claim if they want to prove their entitlement to an indemnity. And your lordship saw the terms of the endorsement and the lost payee endorsement, that the lost payee, whether White Oak or BGIS, has no rights under this policy. It is only entitled to any indemnity or payment insofar as Westford UK or DMCC prove that. This was a relationship that Westford UK and Westford DMCC voluntarily entered into with these lost payees. They decided that this would be their financial relationship. They took that burden, and it's not enough for them now to turn around and say, oh, well, we found ourselves in this rather difficult position. And we as UK don't want to pursue this, but we have to. And we are suffering and we are prejudiced by the fact that we can't get any money from BGIS because they're sanctioned. And Miss Handy Elminer is having to fund these proceedings herself. But that is not a reason why these proceedings, the UK proceedings, should be stayed, because one has to look at all the circumstances in the round. And my learned friend focuses heavily on this undertaking that her client is willing to give. And she said on a number of occasions, it will be as if UK were a party. Now, one needs to unpick that, my lord, because it is clear that Westford UK do not understand why we do not consider the undertaking to do the trick and to resolve or cure the prejudice. And my learned friend said in her oral submissions that there is nothing to stop the defendant from pleading and proving the UK breaches. And first, I want to deal with disclosure, because in the DMCC proceedings, as I've said, disclosure has been given. And disclosure has been given by my client in relation to both the DMCC and UK. Now, the opposite is not the case insofar as DMCC is concerned, because other than I understand a handful of documents, they have not disclosed or been willing to disclose UK documents in those proceedings, my lord. And this is important. And I want to take you, if I may, to section A6, pages 13 and 14. And let me get you the reference. It's at page 77 and 78 of your bundle. And my lord, this is essentially a Redfern schedule, the first page of which is at page 65, and it's the defendant's request in the DMCC proceedings to the claimant for the production of documents. And if you look, if you will, at number 17, the defendant requests documents between UK and Phoenix's liquidator, sorry, UK, HFW and Phoenix's liquidator, including but not limited to correspondence. And then you'll see in the third column, the reasons given by the defendant is that it's consistently been D's position that the claimant's claim and UK's claim should be managed and tried together, and that Westford UK's claims are relevant to these proceedings for the following reasons. And then we have it A, C and Westford are joint insureds under the policy, meaning that if there is a breach by one Westford entity under the policy, that would impact the rights of the other, amongst other things. And you'll see in the final column that DMCC objects to this request on the grounds of lack of sufficient relevance or materiality. Westford UK are not a party to these proceedings, and these proceedings do not concern claims in respect of sale contracts 11893 and 11894. And my lord, those are the two claims that are the subject of the UK proceedings. And you'll see again at 18 and 19, my client requests in the DMCC proceedings documents relating to contracts 11893 and 11894. And those are the two transactions in the UK proceedings. And again, final column, the claimant objects to this request on grounds of lack of sufficient relevance or materiality, and that Westford UK are not a party to these proceedings, and C is not seeking to recover in respect of contract number 11893. And then towards the end of that, there's no pleaded case from either party that the performance of that sale contract is anyway relevant to the claim brought by C. And my lord, so what we have, and the court did not order and agreed, did not order the provision of those documents in the DMCC proceedings. But my learned friend says, oh, well, the UK proceedings can be stayed or should be stayed, and that nothing stops us from pleading and proving the UK breaches. And let me tell you what's happened, my lord, in the DMCC proceedings since disclosure. And I should just say that we are still waiting further disclosure from Westford DMCC. They've written belatedly to say that there are some further documents to be disclosed, but there has been a detailed amended defence. and you'll find that, let me just get you the reference. It's A4 for Mr. Sullivan. And you'll find the amended defence, my lord, at page 14 of your bundle. And you'll see that the amendments are in red. And if you could turn, if you will, to page 21, you'll see that following disclosure, and we also obtained some documents, as you'll have seen from the skeleton, from the liquidator as well, there are detailed amendments relating to the transaction that is the subject of the DMCC proceedings, including at 12.2, evidence we say is relevant to the failures of Westford DMCC to carry out or undertake sufficient due diligence under the policy. And you'll see, if you keep scrolling through, the vast amount of red that has followed in these amendments and have led to various contentions by the defendant in support of their avoidance of the policy. And you'll see that also in relation to the failure, paragraph 40, if you turn to page 35, you'll see at paragraph 40, there's a plea that DMCC breached D.2 of the policy, requiring the claimant to act prudently and as though uninsured and use due diligence and so on. And in red, further particulars given that DMCC had not established even basic information about the identity of Uno Trading, and that was the supplier or the purported supplier of the goods in that case. Now, this is relevant, we say, my lord, to what is likely to happen in relation to the UK proceedings. Because whilst my learned friend says, oh, well, everything's very similar or the same, and that everything can be bound and be dealt with by the undertaking, that's not correct. Because in the UK proceedings, the two transactions, whilst trades or purported trades of rice, and whilst the buyer or purported buyer was Phoenix, there was a different supplier, and that different supplier was genuine, or was called, I should say, genuine. And so, whilst my learned friend is taking you to some common issues in relation to, for example, the breach of C1 and the credit management procedures, there will almost inevitably be issues relating to UK's conduct that is unique to the UK proceedings in relation to genuine as the supplier. And we haven't had disclosure, my lord, in relation to that, either in the DMCC proceedings or by Westford UK in the UK proceedings, because we haven't got to the disclosure phase. And so when one comes back and circles back to this undertaking that is being offered, what UK says is, well, we are willing to abide by and be bound by all findings made in the DMCC proceedings by the judge. Now, the reason that my client can't give that undertaking is because if the judge were to make findings in those proceedings against UK, so if in a trial of the DMCC proceedings separately, the judge were to make findings against UK about UK's conduct in relation to this other transaction genuine, and those findings were to go in UK's favour, my client couldn't be bound by that, because it would want to say, well, we haven't yet had all of the disclosure We haven't yet been able to cross-examine on all of the issues, and we'll need to deal with that in the UK proceedings. And so there lies the problem with my learned friend's client's suggestion that all of this can be resolved and cured by an undertaking. It's not as straightforward or as simple as my learned friend would like. And the emphasis and reliance that is placed in all of this, the pragmatic solution in inverted commas that my learned friend suggests, is merely intended or designed to support her primary contention, which is they don't want the UK proceedings heard. And they don't want the UK proceedings heard because they say it is unfair for UK to pursue a claim where the UK says it doesn't derive any benefit. But that is not a valid justification, nor is what is described as reputational risk. And the submission from my learned friend boils down in that regard to this, which is that White Oak, who are the lost payee for DMCC, don't want to be associated with the lost payee for UK. And that is because of the sanction that BGIS is subject to. But that is not a reason that trumps or should persuade a judge or persuade your lordship to have that proceeding or set of proceedings stayed, when that wouldn't be just or fair for my client in relation to the whole picture. And one has to put all of the circumstances in the pot. And my learned friend has taken you to the Athena case and quite rightly points out that there is a single test, which is it's in the interest of justice for a case management stay to be granted. But she didn't read the sentence before, which said the court will therefore need a powerful reason to depart from its usual course, and such cases will be by their nature be exceptional. So whilst there is a single test, and that's the interest of justice, and whether it's in the interest of justice for a case management to be stayed, in this case, we say that it's not in the interest of justice, and that Westford UK haven't, and the onus being of them, of course, haven't established that it's in the interest of justice to have the UK proceedings stayed. My lord, the defendant submits that everything points to these cases being managed together and heard together, and that the UK proceedings shouldn't be stayed. My lord, we're very much ahead of schedule. Could you just give me one moment while I just check if there's anything else I need to say?
Yeah.
My lord, I'm grateful for those 2 minutes. Those are my further submissions, unless I can be of further assistance to you.
No, thank you. Yes.
My lord, the unusual and compelling circumstance in this case is, of course, the sanctions point. It's not simply that Westford UK will derive no benefit because all the benefit will go to the lost payee. The point, it is common ground. Even if a judgment is given in favour of Westford UK, enforcement of that judgment would involve breach of US, EU and UK sanctions. In the foreseeable, I mean, we don't know if or when sanctions will ever be lifted. At the moment, it seems vanishingly unlikely that any judgment could ever be enforced. And yet here is the insurer insisting on the trial of this essentially pointless claim, a great expense to itself and Westford UK, in circumstances where the judgment will never be enforceable. My lord, just a few further points. In terms of disclosure, you can hear how speculative my learned friend's case is. He says, well, we think that Westford UK should be dragged into this completely unnecessary trial because something may turn up on disclosure that will help our case on failing to act as prudent uninsured. I mean, it's entirely speculative. We know that they will have documents from DMCC, and they are applying for disclosure of the documents from the liquidator of Phoenix relating to all of these contracts. They will have ample material if they wish to make good their case of breach against Westford UK. But as you've seen, that the breaches alleged are generic to the two claims. The allegations against the two insurers are materially identical. And simply the hope of maybe turning up an email or a couple of emails of disclosure is not a sufficiently good reason to put those ways into the balance against the completely unnecessary waste of time. It's also a waste of the court's time. I mean, this trial is bound to be longer if you add in another party. Why should the court be allocating its scarce resources to the hearing of a claim which everybody agrees won't lead to an enforceable judgment if the insured succeeds? Anyway, and the other point made by my learned friend was that his clients aren't willing to give an undertaking to be bound. Well, so be it. I said we'd take the risk. If that's what they want to do, if they want to have another trial all over again, well, we'll take that risk. We think it's vanishingly unlikely, as I said before. My lord, those are my suspicions.
Well, thank you for that. Any other point we need to I need to know about, or because I see some items about the disclosure application, but I think I don't think this is the right time to discuss it here.
My lord, you are right. There is a pending non-party disclosure application against the liquidator. That was requested by my client to be dealt with on the papers. I think everyone has agreed that it should be expedited. I, in my skeleton, dealt with the kind of headline key points in case the court were prepared to deal with this today. But my lord, I don't know whether you've had time to look at the papers or the application or my skeleton in that regard.
No, I haven't, and I think it might be dealt with another judicial officer, not necessarily by me. Let's see how it goes.
My lord, then all I would say is that I'd ask you to bear that in account, that we have that pending application in relation to documentation that hasn't yet been determined, just in the context of the timetable for both of these sets of proceedings.
Good. Thank you. So I will reserve my my order. I need to take a little bit of time to go through this in details after the hearing both counsel today, and you will be informed by the registry before, I hope, before end of this week about my decision on those pending applications.
Thank you, my lord.
All right. Thank you.
Thank you, my lord.
Thank you.